Hi, everyone. This week we have a short lecture. I'm talking to you about chapter 16 today from our book, in which we will be looking at legal controls and freedom of expression as these issues relate to mass media. So, to start, when we talk about freedom of expression in the United States, this is rooted in the five rights outlined in the First Amendment of the US Constitution, which states Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. So, as outlined in this amendment, we are guaranteed the rights of freedom of speech, free exercise of religion, freedom of press, freedom of petition of the government, and freedom of assembly. All of these freedoms are relevant for thinking about mass media, as they outline our rights in relation to how speech acts work in and through media. Freedom of speech doesn't mean that you can say anything, though, and there are some types of speech that are generally not protected by the First Amendment. This includes things like obscenity, fighting words or hate speech, defamation, which includes libel and slander, child pornography, perjury, blackmail, incitement to imminent lawless action, true threats, solicitations to commit crimes, plagiarism, and treason, all of which are more clearly outlined in your book. Who does this apply to? This becomes an important question for us to ask for the purposes of our class. So, where do these freedoms apply? Do they apply to all of us as individuals? Do they apply to companies or institutions? Do they apply online the same way that they do in person? So, these are some of the questions that we're going to be thinking about today. In relation to freedom of the press, for example, the courts have historically ruled that newspaper publishers have the right of press and paper purchasers pay for the right to read their material. Over the air terrestrial broadcasters use the broadcasting spectrum, which, as we've discussed in the past, is owned by the public. And so there's regulation there, but there's far less regulation on social media platforms. And this is largely because companies have resisted being classified as media companies, and so currently do not fall under current regulations of media companies, which we've also talked about in the past. So that means that something like a social media platform is not actually listed as a media company. What this means is that newspaper publishers, for example, have responsibility for what is published in their paper since they own the press and the paper. Over the air terrestrial broadcasters are similar, so they have sort of the same conditions. But because the broadcasting spectrum is owned by the public, there are more regulations that can be applied to broadcasting than to newspapers, which are often not publicly owned. Social media companies are more similar to newspapers, really, but have even less regulation than them. And there are so few regulations, as we've discussed in previous weeks, in part because legal regulations haven't been updated as the internet has expanded, which we'll talk about a little bit more in a minute. An important case related to the freedom of the press was called the FCC versus Pacifica from 1978. This case provides the basis of the FCC's legal jurisdiction to censor and control what can and can't be said on broadcast media. But some people argue that because freedom of the press is guaranteed in the Constitution, this kind of regulation shouldn't happen at all, even though there is already legal precedent, which raises a question. Does the First Amendment deny government any power to restrict public broadcast and indecent language under any circumstance? Or are there cases where these restrictions are good and that where we might actually want the government to regulate broadcasting? To answer this question, we can also look at many other court cases that have tried to weigh in on the right of free press or the right of the people to know versus protections for personal privacy, which come up also in your book. For the most part, these court cases have protected strong freedom of press with some minor regulations for severe cases. The New York Times versus Sullivan in 1964 established that the media could publish anything except that which had deliberate malicious intent. Later, Redline Broadcasting Company versus the FCC in 1969 stated that broadcasters were required to give those attacked response time to accusations on air. So if you were to give someone time to publicly speak out against someone, technically broadcasters are required to give the people who have been spoken out against or have been attacked time to respond, equal time, equal space. In Miami Herald Publishing versus Torneo in 1974, it was stated that print publishers, unlike broadcasters, were not required to respond to accusations. So you see some of these differences highlighted a couple of slides ago coming up here, right? Because print is not publicly owned, they're not required to give the same kind of space, the same kind of equal space and time, where broadcasters, because they are using public airways, are required to match time for people to respond. And then finally, in 1988, there's the case of Jerry Falwell versus Hustler magazine. This case outlines emotional distress, even with bad motive, is not a good enough reason to censor a story, even if the claims about the person are outrageous. So in this case in 1988, Jerry Falwell, who was a religious evangelical leader, versus Hustler, the case centered on this famous televangelist who tried to sue Hustler magazine for an exaggerated joke ad printed here. The running joke is about Falwell's first time. It was a series. There were a number of other celebrities that were included in it. And the first time is really about the first time drinking Campari. But in the story that's printed, the first time Falwell's experience with drinking Campari is with his mother. The running joke is that he's talking about sexual relations. And so it's fairly insulting, right? And it's a fictitious story, but he claimed that it caused him a significant amount of emotional and reputational distress because of his status as a public conservative and Christian figure. But the court in this case ruled that as a satirical ad, and it did say very clearly on the bottom that it was satire in very tiny print that you can see there, the court still ruled that as a satire, this didn't count as definite defamation. So although Falwell was embarrassed, it wasn't really slander because it was trying to be a joke and it couldn't be taken as serious. And so therefore it couldn't be regulated and didn't need to be censored in any way. So more recently, though, this prior to tradition of strong press protections have come into question, especially around issues of defamation in different ways. An example that took a very different approach is from 2016, when the professional wrestler Terry Hulk Hogan sued Gawker Media for publishing a tape of him sleeping with the wife of his best friend without his knowledge. Hogan's lawyer argued that the publication of the video amounts to an invasion of privacy and that it had no news value and that it only served as fodder for the reader and clicks for a source of advertising revenue. Essentially, the story wasn't really anything. It only served to hurt Hulk Hogan and his reputation and didn't really have any actual newsworthy content or material. And so there was nothing about it that suggested that it was important for the public to know this information. The court sided with Hulk Hogan and awarded him $115 million and another $25 million in punitive damages to be paid by Gawker Media. And this actually bankrupted Gawker Media, and they were forced to close operations as a result of this court case. This lawsuit raises what legal scholars say are important and largely unresolved issues about the line between privacy and free expression in the internet era in particular. You can actually see a documentary on this on Netflix called Nobody Speak. Another recent issue related to freedom of expression and the media has been around the right of the free press versus the right to a fair trial guaranteed in the Constitution. Some argue that media coverage sways public opinion so much that it doesn't allow some people to have a fair trial because of news coverage about people who are being tried, and so therefore sways public opinion and tries them in the court of public opinion before they are able to reach trial, and so therefore they are unable to have an unbiased jury. So controversies around this in the 1990s was during the O.J. Simpson trial, for instance, which was very famous. A more recent example was 2017, was the trial of Martin Shkreli. And Shkreli was a man who inflated the price of necessary medications, in particular epinephrine, for people who have severe allergies in order to make an obscene profit, and was very vocal about that. So he was largely considered and talked about in public as a very despised person, and some argued that this meant that it was not possible for him to be able to get jurors because of people's preconceived opinions. We'll watch a video about this in a minute, but also additionally, in our most recent moment, we can see maybe the flip side of this, which is Luigi Mangione, in which there's an argument that there's the possibility that he can also not receive an unbiased trial because he was essentially similarly already declared guilty in the court of public opinion, regardless of whether or not that was seen as he may not have been as vilified in some ways as Martin Shkreli. He still was seen to have already been determined to be guilty via public. So here's that video on John Oliver talking about Martin Shkreli.
And now, some of the actual responses from potential jurors excused from the Martin Shkreli trial. I'm aware of the defendant, and I hate him. No, 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 no. By the time I came in and sat down and he turned around, I felt immediately I was biased. He kind of looks like a dick. When I walked in here today, I looked at him, and in my head, that's a snake. Not knowing who he was, I just walked in and looked right at him, and that's a snake. I think he's a greedy little man. You'd have to convince me he was innocent rather than guilty. The only thing I'd be impartial about is what prison this guy goes to. Is he stupid or greedy? I can't understand. He disrespected the Wu-Tang Clan. Wu-Tang Clan ain't nothing to fuck with!
Welcome back. A live look now at the Manhattan courthouse, where in the next hour we expect to see the man accused of killing the CEO of United Healthcare. Luigi Mangione set to appear in court for the first time since December. CBS News legal contributor Jessica Levinson is joining us now. Jessica, thanks for being here on a Friday. We know this case captivated the country. It will be hard to find someone who has not heard something or another about this. So how much of a distraction could this be, especially when it comes to picking jurors?
This is a really important question, because the issue for jury, if we do get to the point where we're picking a jury, and we should just pause and say the majority of cases, both civil and criminal, don't end up going to a jury trial. But if we get there, how do you pick a fair jury? And the answer is, we're not looking for people who have never heard about the case. And frankly, I don't think we're even looking for people who don't have a view of the case. What we're looking for is people who can walk into that jury box and then later into the deliberation room and say, here's the applicable law, here are the facts that were presented to me, and I'm going to make a decision only based on that. So certainly when there's a high profile case, jury selection called voir dire, it tends to be more intensive, but it doesn't mean that we can't get a fair jury just because this is such a high profile case.
As we saw in the video, public opinion affect people's ability to receive a fair trial. So that was one of the critical issues that still faces this conversation about the public's right to know and free press. There are some other important issues about corporations versus individuals in terms of First Amendment protections as well. So a huge question throughout U.S. history has been, does the First Amendment apply only to individuals, or do institutions and corporations also benefit from these freedoms of speech and press protections? So a recent development in this issue, the court case Citizens United versus Federal Election Commission in 2010, it was ruled in favor of what is called corporate personhood, meaning that free speech rights could apply to corporations. This is potentially incredibly problematic because it means that corporations who have significantly more resources and more power than individuals can use those resources in ways that are protected by the First Amendment. So donating significant amounts of money to a cause, which brings up some of our questions from the week on PR about, for instance, astroturfing or lobbying as a form of public relations and how that ties in with things like corporate social responsibility. So because these are protected rights, corporations utilizing them can claim that they are using free speech when in fact actually they're working to influence. So net neutrality is another important issue that relates to freedom of speech rights. There's a full video that I'm about to play here.
It's hard to overestimate just how much broadband changed the internet. Back when you had to connect to the internet using dial-up, information traveled slowly, pages took forever to load, and watching this video would have been impossible. Today's internet is a completely different creature, which is why it's so puzzling that the last time Congress passed major legislation for regulating the internet, it was 1996. And so the task of regulating the internet has fallen to 5 unelected bureaucrats, the Federal Communications Commission. As the tools we use to access the internet have changed, they've had to decide what kinds of rules the companies that provide those tools should have to follow. And now, under a new commissioner appointed by President Trump, the FCC has altered those rules in a way that could fundamentally change how we use the internet.
Take a deep breath. This decision will not break the internet.
This decision puts the Federal Communications Commission on the wrong side of history.
It creates a free-for-all that we have not had on the internet in the past. And that's very, very dangerous.
It's gonna be What we're seeing here is the cableization of the internet.
This is a dark day for innovation. This is a dark day for small business. It is a dark day for consumers.
First, let's define what most people mean when they talk about net neutrality.
A good working consensus model that most would agree with is the idea that internet service providers should treat all traffic more or less the same on their network.
This means the companies whose wires and towers we use to access the internet can't block or slow down data from certain sites or apps. They can't make special deals to move certain data along faster than everybody else's. Internet content providers like Facebook, Google, and Netflix, they love net neutrality because it means that even if some of their products, like streaming this video for example, take up a lot more bandwidth than others like email, internet service providers can't charge them extra for getting all that data to our phones and computers. Which is exactly why ISPs like Comcast, Verizon, and AT&T hate it. If they could charge Netflix and YouTube extra for those big packets of data, they could make a lot of money. And now that the FCC has scrapped the net neutrality rules, they almost certainly will. ISPs will also be able to charge customers more to access sites or apps that take up more bandwidth. And some argue this will mean more choices for consumers.
My sense is this would be fantastic, right? Because my daughter chews through my Verizon data cap every month, and all she ever does is Instagram. So if I could pay like $20 and get her a phone that I could text with her and talk with her, but would allow her to use Instagram and get her off my standard data plan, that would be great.
But by privileging established tools like Instagram, these plans could make it a lot harder for new ones to break through.
It's a time when more than ever we want to encourage and keep open a playing field for new services, new platforms to be able to get in the game and provide a real alternative. I mean, imagine a world in which we were all still stuck with MySpace. I don't think, that's what we want, but net neutrality is part of why that's not what we have.
Until 2005, internet service providers were classified as common carriers, which meant the FCC could regulate them like phone companies. In the internet's early days, these regulations kept phone companies from charging customers extra for using dial-up services like AOL. And when phone companies started offering DSL broadband service over their lines, common carrier rules forced them to let their competitors use those lines too, which meant consumers had tons of choices when it came to picking an internet service provider. A 2003 page from the Washington Post lists 18 different DSL options for the Washington, D.C. region. Today, residents have less than half as many choices. So, what happened? In 2005, the FCC did the same thing it did in 2017. It said ISPs weren't common carriers, and it stopped regulating them like phone companies. And without that regulation, ISPs became virtual monopolies. Today, 2/3 of Americans live in areas with just one choice for high-speed internet. And if their ISPs start blocking, slowing down, or charging more as a result of this rule change, their options are to put up with it or go without the internet. Despite the fact that majorities of both Republican and Democratic voters support net neutrality, it doesn't look like Congress or the FCC will be bringing it back anytime soon.
So, as discussed in the video, the issue here that's relevant for freedom of expression and free speech is the issue of having equal access or equal lanes in this visual is like a good representation of what we're talking about, where the fast lane would give you quicker access to certain sites if you were willing to pay more, but you might also be stuck in a slow lane that wouldn't really give you the same equal access. And we've talked about this in the past of who is it that would end up having more rights, right? That video has some really great conversations in it too about who's interested in this and why and who isn't, right? Another really big issue right now is the regulation of online speech. And as I mentioned earlier, internet service providers and online speech is not really federally regulated at all currently. There's a very intense debate about this because of the ramping up of problems related to the spread of misleading information. So misinformation, disinformation, fake and false news, as we have seen and discussed around the spread of conspiracy theories like Pizzagate and then also QAnon. And throughout coronavirus, there were a lot of concerns about misleading health information being spread online as well. And so as a result, people have suggested that there should be more regulation of speech online, with more materials being flagged or removed from sites. And in recent years, we saw a lot more of examples of this around companies like Twitter, now X, and Facebook having at one point built up more content moderation at the behest and pressure about the kinds of speech that were happening in those spaces, and so they had fact checkers put in place. And then we're starting to see now an era of the breakdown of moderation in those spaces. So both X and now Facebook have removed moderation in favor of like content commentator notes, which arguably has actually opened the floodgate for more mis and disinformation. Hate speech as well has grown in these spaces, and incorrect information is being promoted. So that kind of content regulation has been suppressed in some ways, and yet at the same time, we're also seeing the rise of criticisms of entire platforms for supposed misinformation or disinformation. A lot of the concern supposedly around TikTok has not only been the data being owned by a non-US company, but also the fact that because it is not a US company, those who are moderating speech are not doing it in the ways that people in American politics would prefer at this moment. So, and they argue that these things are biased. But it's important to remember that, again, because these are private companies and private platforms, they technically have no current obligation under the legal structures that we have in place to uphold free speech or to moderate speech in a way that is deemed to be socially beneficial, right? Right now, they have no structures in place from a governmental level about how to manage that. And that's why we see things like criticisms of data usage being mobilized to do things like argue for the shutdown of TikTok in the United States. There's some other problems that have come up related to content moderation and arguments about censorship. Although I mentioned that these companies technically don't have to uphold First Amendment rights as private companies, many people view these spaces as important to the public sphere and for expressing ourselves, especially, as you can imagine, during lockdown, right? When it became one of the few places we had for public forums. So many content creators in particular have spoken out about these forms of censorship. They feel like the platforms have imposed upon them through strategies of demonetization or by stopping paying content creators when they have materials in their videos that are deemed not advertiser friendly. Sometimes this is because it might be that they're using hate speech. It might also be that they could be mentioning something like a violent event that happened in the world or talking about issues that are seen as controversial. So people faced issues of being demonetized, if not fully deplatformed. Many of these creators argue that demonetizing videos on these topics effectively works to censor them because it will discourage creators from talking about these things, which makes these ideas less visible and accessible to people. And some argue ultimately then that this is infringing on people's freedom of speech. In early January of this year, the Supreme Court heard arguments in one of the most important First Amendment cases of our time, TikTok versus Garland, brought by TikTok and its users. The suit challenges a law passed by Congress that will functionally ban the platform. In the U.S., it was supposed to start January 19th. There have been a number of temporary reprieves. But if upheld, the law won't just impact the more than 170 million Americans who use TikTok, not only for information, but often for personal businesses and other aspects. It will also endanger the constitutional rights of Americans to speak and receive information online, according to the ACLU, right? The Department of Justice has argued that the law has two purposes: to limit the Chinese government's ability to covertly manipulate what Americans see on TikTok, and to prevent the Chinese government from accessing Americans' data. But given the lack of evidence that TikTok is being exploited in either of these two ways, which came out through many of these hearings over time, neither of those two arguments sufficiently justifies the First Amendment's high bar of what is allowable for the government to control as far as the free flow of ideas. The law at issue would give the president unprecedented power to shut down platforms for speech and access to information under the guise of protecting national security. It would require TikTok's parent company, ByteDance, to sell the app or to face a ban, while also granting the president broad authority to force divestiture and ban other communication platforms with corporate parents based in China, which we're seeing in other forms now as well. The ACLU and its partners filed with the Supreme Court under the First Amendment. The government would need to meet an extraordinarily high bar to ban an entire communications platform. To ban TikTok, the government must show that the ban is the only way to prevent serious imminent harm to national security, and that the ban limits no more free speech than necessary to accomplish that purpose. According to the ACLU, the government has not come close to meeting that standard. So this is the moment that we're in right now. This is all still being essentially debated. There have been a number of congressmen who have voted one way and then pushed back, et cetera. So we're still waiting to see what's going to happen with this. But what I want you guys to think about is the difference between regulating speech on a platform and assuming that would be protected speech, right, when it's a private company, versus what's happening here, which is the government coming in to shut down an entire platform, right? So those are two very different things, and it is the scale at which this is happening and the fact that it is a government control that would be put in place by this law that makes it a First Amendment issue, where moderation of content or even things like shadow banning by platforms is not technically a First Amendment violation, which we'll talk about more when we go through some more examples. So think about these things in terms of who is it that's exerting control and whether or not that makes it protected under federal regulations of free speech under the First Amendment. So finally, I want to run through some issues and discuss whether or not they are actually protected by the First Amendment. And this relates to the writing exercise this week, because I think you'll find it interesting to see what people think is and is not covered by the First Amendment. Seeing the differences in generational perceptions on this might be interesting to you. So first, case number one. You're banned from a social media platform. This happened a couple of times on a large scale around people like Alex Jones, but also in much more kind of small, mundane ways. People get banned from platforms somewhat frequently, or, temporarily banned, shadow banned, etc. While you might think this is a First Amendment issue, it actually isn't. This scenario illustrates one of the biggest misconceptions people have about the First Amendment. The bottom line is that it protects you from the government punishing or censoring or oppressing your speech. This does not apply to private organizations. So again, if Twitter, as a private organization, decides to ban you, you're kind of out of luck. You can't make a First Amendment claim in court. However, while it's not unconstitutional officially, if private platforms outright ban certain types of protected speech, it's an uncomfortable precedent for the values of free speech, and one that's still very important for us to think about. Case number two. You're fired from your job for something you say in public or online. If you work for a private company, it's probably not a First Amendment issue. Ultimately, it's often the company's right to discipline their employees' speech. So just because, and they do this through the language of keeping in kind with the brand image, etc., right? So just because the private employer has the right to fire someone, this doesn't give them legal carte blanche. So depending on what the fired employee said, the employer could be in violation of a Civil Rights Act or possibly in violation of contract law. If you're a government employee, though, this is a complicated issue. Institutions like police departments, public schools, and branches can't restrict employees' free speech rights, but they do need to assure that it doesn't keep the employee from properly doing their job. It's definitely a kind of fuzzy balancing act, and the rise of social media has made it much harder for institutions to regulate this. Case number 3. A university or public group cancels a speech or presentation by a controversial figure. If it's a private institution, again, it's probably not a First Amendment issue. If it's a public institution, the lines can get pretty blurry. So in the case of Rutgers, which is technically a public university, you invite someone to speak on your campus, and if you're at a public university, you have to respect their First Amendment rights. But that doesn't mean that you can't put regulations on speech, like dictating the time, place, venue, and suggestions for subject matter. It just means that you can't do it in a way that discriminates against a certain point of view officially. If students protesting play a hand in moving or canceling the speaker, that presents a different free speech challenge. If the speaker were to take legal action for being blocked from speaking, which has happened, that they can't do it again. Students can't take a constitutional action against a group of private citizens. So, in other words, they can't attack the students. Such a complaint would have to go against the school for allowing the constitutional breach to happen. Case number 4. You're arrested while recording police activities in public. This is definitely a First Amendment issue. While there are exceptions and nuances, this is definitely unconstitutional. If you are trying to incite people with your speech, but even then it needs to be a true threat in order to actually justify the arrest. It needs to be a true threat, one that has some sort of immediacy, an actual intent for it to not be protected by the Constitution and the First Amendment. Case number 5, you're arrested for saying something critical of the government. So this is also definitely a First Amendment issue with the same considerations as our last example. It is unconstitutional for you to be arrested for saying something critical of the government unless you're trying to incite people to violence with your speech in a way that makes it a true threat legally. Case number 6. Your comment or post is deleted from an online forum. As we've discussed some already, this is a private company, so it is not a First Amendment issue. Private companies like social media sites can basically do whatever they want. Finally, case number 7. You were fined by your employer or institution for not standing for the national anthem, and this also happens for expulsions for students. So this absolutely 100% is a First Amendment issue, at the very least in spirit. So symbolic speech is protected by the Constitution. So in essence, you have the right to not speak. You have the right to silence. In theory, a private employer could require you to stand for the anthem or say the Pledge of Allegiance, but such requirements may open them up to lawsuits under the Civil Rights Act. So even in schools where there have been some cases of students being singled out for sitting or for kneeling for the anthem, it would be hard to provide justification for punishment from the school, right? Whereas the school is the one who is actually in violation. This is an act of political speech, which is traditionally the most protected type of free speech. And it is completely not disruptive, of course, because it's also silent. So there's really no argument against why this wouldn't be protected.
Okay, that's it for this week. Please be sure to read chapter 16 and the article that's assigned as well. There's also some optional videos there. And do the Achieve assignments for the week. You're obviously already watching this lecture, so we're good there. Do your discussion posts this week. We'll be obviously talking about the First Amendment and legal protections. Don't forget to check out your classmates' mass media mini lectures. I think we only have 1 or 2 this week. It's pretty small, so be sure to give them good, meaningful feedback. And the writing analysis option for this week is based on that little quiz that we just did in the lecture of what is and is not protected speech, where you're going to do the same exercise as a survey with some people in your life to find out if different groups of people, depending on age or education or whatever way you decide to break down your demographics, have different understandings or different expectations of what is or is not
First Amendment protected speech and may be more or less correct. So I look forward to reading those, especially if you have not done a mini survey as one of your writing options yet. Remember, you all have to do one that's a mini survey. Only one can be content-based. You can do 2 mini surveys if you prefer, but make sure you do at least one. If you haven't yet, this is a good one to do. It's kind of fun to find out like what your family thinks about things, and it's a good way to give them some information they might not already have. All right, I hope you have a great week. Take care. Bye.